Hi, everyone. So today I want to finish up with part three of my review of the case of Kegler versus Attorney General, the case that was before the Massachusetts State Supreme Court concerning the right to die. So, in the third part, we're going to hear oral arguments from an amicus appearance, right? This is an attorney who was appearing on behalf of the Euthanasia Prevention Coalition. So I mean, I think I explained it in the last video. Amicus curiae, they're basically a friend of the court. You're not a party, but you can file a brief as advice to the court. And again, I wanted to file a brief myself, but I didn't have time, and I didn't know about the case until I was well into it. So um, before I get started on playing the video, I want to show y'all what this organization is about. Okay. So the purpose of the Euthanasia Prevention Coalition: preserve and enforce legal prohibitions and ethical guidelines prohibiting euthanasia and assisted suicide. Educate the public on the harm and risks associated with the promotion of euthanasia and assisted suicide through the use of pamphlets, information, seminars, media campaigns, and research articles. Um, I'm going to skip down to the bottom because I want to get started. We aim to present a united voice in presentations to governments and other organizations with respect to issues related to euthanasia and assisted suicide, network and exchange information between members and concerned people. Um, and here's the part that I'm interested in is create the opportunity for informative debate. I don't think there are any rigorous debates on this issue. I have tagged this organization in this live stream because I would love to debate them. I think this issue is so one-sided. Um, they're saying that there's a growing tendency to promote assisted suicide as a solution to suffering, aging, mental or physical challenges, social ills, rising health costs, and cost containment. Yes. I mean, is there any other solution to aging? Is there any other solution to suffering? Right, because they're going to say is that they can give you palliative care, but is that going to prevent you from aging? Is that going to do anything to eliminate your medical debts? Like, and then they talk about depression. Depression. I'm sorry, I've been depressed at least since I was 8 years old, and it hasn't gone away. So I don't. I mean, they always talk about like it's so temporary. It's not temporary for a lot of us. Some of us just don't want to be here, and we don't see our lives as having any purpose or meaning. So with that, I'm going to go ahead and get started and play this video. um let me switch it. Okay, here's the tab.
Good morning, Your Honors, and may it please the Court. My name is Chris Shandeville, here today on behalf of Euthanasia Prevention Coalition USA in support of the appellees and in support of affirmance of the decision below. As this Court recognized just last month in Commonwealth versus Roman, only rights that are deeply rooted in the history and tradition of this Commonwealth and the nation can qualify as fundamental rights under the Massachusetts Constitution. And Justice Cipher, in response to your earlier question.
Right, and that's the reason I think that the attorney for the appellant framed the issue incorrectly, right? Because he framed it as a right to direct one's medical decisions. It should have been framed as the right to life, because included in the right to life is the right to die. Um, and I think if he would have framed the issue a little bit differently, we might have. I don't know that the result would have been different, but we would hear different arguments from the attorney general and the amicus appearance. So I think he made it entirely too easy. Again, I think they would have decided against the appellant anyway, but um, he, d- I think it would have at least opened the door for future debates and maybe to revisit this issue at a later point. Maybe we could have gotten a compelling dissenting opinion, which could have been used for future law. But no, I just think he did a very terrible job.
About whether we're doing that analysis under the due process provisions in the Constitution, under the equal protection provisions. I don't think the appellants have been very clear as to where they're asserting those rights. However, in terms of the test for what constitutes a fundamental right, the test is the same. So in Gillespie and then in Wilbur, those cases were due process cases. Roman, of course, was an equal protection case. In both cases, the question is whether or not a fundamental right exists. And in all three cases, this court said the test is whether or not that right is deeply rooted in history and tradition. So-called medical aid in dying fails that test for at least three reasons. First of all, suicide and assisted suicide both have been long prohibited in this Commonwealth and throughout our nation's history. Second, so-called medical aid in dying is assisted suicide. And third, as this court explained and clearly stated in Guardianship of Doe, quote, "It is well settled that withdrawing or refusing life-sustaining medical treatment is not equivalent to attempting suicide."
Okay, I mean, I didn't do any research recently as it relates to the common law on suicide. I know that it was highly frowned upon on the common law. That basically they didn't punish. I mean, obviously they can't punish the person who terminated his or her own life, but they would punish the family. A lot of times they would take away the property. There would be it would basically be a scarlet letter on the entire family that that person's, I don't know, the husband terminated his life, and then it would there would be a stigma placed on the children, basically on the entire family. I think most of that was societal, aside from the fact that I think that if you terminated your life, the children would not be able to inherit the property. This is so backwards. Like, why are you punishing the children for something that the parent did? I mean, I do think it's selfish to terminate your life if you have children, but if you don't have children, then what is the harm?
Let me stop you there and ask you a couple of questions. One is, if we're talking about things that are rooted, deeply rooted, but yet recognizing that our common law can change, so we've got a constitutional issue and a common law development issue. At the time that the prohibitions were originally came up with, there was no simple guaranteed method of a painless death that a physician could offer. So this is really something that's new, isn't it?
Well,
relatively speaking.
Well, so the argument on the other side is that medical aid in dying is something that is new and different. Since the U.S. Supreme Court's decision in Glucksberg and Vacco in 1997, both those cases involved so-called medical aid in dying. If you read the facts of what the plaintiffs were asserting there, they were asserting a right to lethal medication from their prescribing physician, and they were asserting they were competent adults. The exact same claim that's been made in this case, and the majority opinion in both of those cases walks through the history and tradition and says there's simply no right like this anywhere within our nation's history or tradition.
Right.
So
Well,
the analysis...
But let's stop there for a minute and say, isn't there a distinction often between Massachusetts provides more protections in many ways to, or can provide more rights than the federal government can? And so what in the Massachusetts Constitution would prevent us from finding that this is a fundamental right?
So a couple of responses to that, Your Honor. So in the Gillespie case, where this court did apply the deeply rooted history and tradition test, in footnote 12 of that decision, the court did explain that at times this court is willing to go further and find more robust rights to due process, et cetera. But the very next line after that discussion in that footnote 12 in Gillespie is that this court continues to apply the same standards that the federal courts apply.
This is very confounding, because this is an attorney, right? Attorneys make a lot of money. Um, he has this organization, the Euthanasia Prevention Coalition. I'm curious as to who's actually funding this. I mean, I would assume that he's making this appearance without compensation. Why would he? I mean, who cares, right? Why does he care? It's not his family. It's not his love. What is his interest in this case? I don't understand that. I mean, the reason that why I would care is because it affects me. I don't necessarily want to grow old. Um, so it has a real impact on my life. I don't understand why he's even. I mean, whatever. I mean, I would love to debate this person. I doubt that he's going to do that. I mean, maybe he'll do that on my other the Black Anarchist channel because that has more more subscribers. Gosh, I would love to debate this person.
So that's all we're asking the court to do here, is to continue to apply that standard of requiring that the asserted right is deeply rooted in history and
Right,
tradition.
I have one last question, and
Yes,
then
Your
I'll
Honor.
be quiet, and that is that this this issue here with regard to, I guess, whether it's within our Constitution or we're following the federal Constitution and we're adopting that language, what in the history of the nation and the history and our traditions is not related to religion in this area? Is there anything that shows that this is not a religious issue?
Sure. So if the court would examine the decisions of this court dating all the way back to Commonwealth versus Bowen, which was the case of the inmate next to another inmate and the encouragement to commit suicide and the commission of the suicide. In that case, other cases which followed that one, which are discussed in our brief, and cases from other jurisdictions as well, there's never an assertion that the common law prohibition on suicide and assisted suicide is based on religious beliefs. It's always based on the government's interest in protecting human life. And that interest is not limited to religious concerns. And I think the amicus brief filed in this case by Dr. Ewell in support of the appellees and in support of affirmance, he made very clear that he's an atheist and doesn't believe in God, and yet the state has very important interest in a case like this in making sure that suicide and assisted suicide remain prohibited. So we don't think it's based on anything within religion.
I really have a problem when they do this because they always talk about how the state has an interest in this or that. They never tell you what the interest actually is. You're just supposed to just assume that the state has an interest in it, but they never actually articulate the state's interest. Um, Presumably, the state's interest would be in tax revenue. Um, I don't know. I can't even try to speculate as to what the state's interest would be, other than the fact that you don't actually own your life and the state actually owns you, so they would be losing one of its subjects. Because if you actually do own your life, then the state would have no interest in it whatsoever. But I mean, again, I wish I could have been a part to this, or maybe there would be a corollary case where I live. I um I don't know. Maybe I can be the one to. No, I don't know. I don't think I'm the right plaintiff, but I would love to art. Maybe even if I could just debate him on YouTube, I would love to do that.
Okay, but doesn't that bring you right back to Justice Wentland's question? And that is, what interest does the government have in this doctor having a painful death?
So the government has an interest in making sure that all human life is protected. And part of the reason why that deeply rooted in history tradition test is so important to apply here, there are two reasons. One is more principled, and the second is more practical. The more principled reason is that, in the words of the panel decision in the Compassion in Dying case, which eventually became Glucksberg, applying that test prevents courts from becoming essentially a free-floating constitutional convention, able to create new rights based on their own policy preferences. And then secondly, the more practical reason why that applying the test here is so important is because it would avoid this court creating a new constitutional right that this court and the lower courts it would be impossible for them to cabin to the narrow class.
Let's take both of those. First of all, the language you're quoting is from a substantive due process analysis.
Yes, Your Honor.
And then the New York case is a equal protection case. And what the plaintiffs have not precisely articulated the difference between the liberty interest and the privacy interest. Nonetheless, what about the privacy interest? What about the penumbra issue, and why doesn't this fall within the right to privacy?
So as we've explained in our brief and going through some of the court's cases,
Again, if I were arguing this case, I would say the equal protection argument would be that, first of all, animals have the right to die. Cats and dogs have more rights than human beings when it comes to this issue. Criminals have the right to die. And so they're basically creating a distinct class of law-abiding citizens and punishing them and denying them the right to die. Um, Again, I would have framed it as the liberty issue would be the state is essentially taking someone's life for a public purpose. Like, you don't get to live for your own purpose, because if it was your life, then you get to. I think I explained this one from Plessy versus Ferguson. It defined what slavery is, and it's the deprivation of the right to the disposal of one's own person, property, or services. So by forcing someone to exist against their will, you're basically enslaving them to the public. Um, I think I could have made much more compelling arguments than that attorney, and um, the burden is on him, right? So because he did not make a compelling argument at the outset, now it's just so easy for them to just dismiss this case and going about their business. So I don't know, man. I mean, again, I think he hasn't thought about it because it's not close to him. Home, he's getting paid for it. It doesn't actually affect him. He doesn't actually want the right to die. It would take someone like me who actually has thought long and hard about this, how it actually impacts my life, to actually present those arguments. I don't think that the average attorney would not actually care.
that locate this right to reject medical treatment. The court does discuss a couple of things. It discusses that liberty interest and really the common law interest in being able to reject a battery. We think that's an important distinction, which should prevent the court from expanding the right to reject medical treatment to what's being asserted here, basically a right to invite a bodily invasion in the form of that lethal medication. But also in the rights to privacy, that right in those cases always hinges on the right to avoid non-consensual invasions of bodily integrity. So we think even though the court uses the privacy language in some of those cases, if you read each of those cases as we've laid out in our brief, it always hinges on that non-consensual invasion of the body. And so that is what distinguishes. So for
I'm not
example,
so
in
sure.
And also, I just want to add that the other argument I would make, it would not be based on liberty. It would not be based on equal protection or um, privacy. I would also frame it under the Ninth Amendment, which attorneys never use the Ninth Amendment. That the Constitution does not create rights. Um, it enumerates certain rights, but people retain rights. That there are some things which are beyond the scope of government. So the government can't regulate everything. That is the presumption, that you don't have rights unless the government says you have rights.
But at least the plaintiffs would say that that dichotomy is not going to hold up. In the real world, the way medicine is practiced now with people who are at the end of their life. And while that may have been true before, it's blurring now. And there's a lot of proactive medicine that goes into palliative care.
The important thing
But again, from an anarchist perspective, all medication would be sold in the free market. So you would eliminate this issue in the first place. It should not be left to a closed market by licensed physicians. We don't support occupational licenses. So um, the fact that the government, by the way, occupational licenses did not exist until like the 1930s. There were no law licenses, there were no medical licenses. The people act like this has existed since time immemorial. It really hasn't. There are a bunch of robber barons who run around lobbying state legislatures so that they could um, they would have protection from competition. Economic protectionism is what they wanted. and it was completely self-serving. They act like it's supposed to protect the public so they can get higher standards of competency. It actually lowers competency. It promotes unscrupulous business practices. So I've done content about occupational licenses that they're very tyrannical. But this is the consequence of it. So they're making it seem like they're the victims because no doctor should have to terminate somebody's life or there's a state interest in protect whatever. Like, no, it should not be left to the doctor anyway. It should be sold in a free market, and and then you would eliminate this issue in the first place. There would be no manslaughter because it would be sold by whomever was willing to sell it. You could even get it from another country, right? There's a I believe it's called the L pill, which is cyanide. You okay? I don't want to say that because I might get in trouble on YouTube. I'll leave that part alone.
Your Honor, in terms of the extent to which some of that medicine is proactive in terms of prescribing various forms of pain relief, none of that proactive activity is ever the cause of the death when, in terms of what the court has said about the right to reject medical treatment. It's still a death by natural causes, which the doctors never intended.
By dehydration.
Right, even a withdrawal of nutrition and pneumonia that's occasioned by morphine.
Right, and what the courts have said in those contexts is that but for the natural causes which precipitated the withdrawal of the hydration and the feeding tubes and et cetera, that patient would still be alive. So it's still the natural causes that are the underlying cause of death. And so the intent there, and this is an important distinction between action and inaction. The court, I think Justice Lowy, you asked about the Brophy case, and wasn't that really an active act taken by the doctors? But in that case, what was being asserted was a right to withdraw a feeding tube, the right to stop the medical care that had previously been started. And what the court said in its analysis there is, if anyone has a right to reject medical treatment in the first place, certainly they also have the right to subsequently stop that treatment. So even in Brophy, it was based on, goes back to the common law right to reject a battery. Now, it's a battery that had begun weeks or months earlier when the medical treatment started, but it was a battery that it became a battery anew once the patient stopped consenting to that treatment. So,
And this is where I would give pushback also that the imposition of life is battery. That your parents impose life on you without your consent, and by forcing you to continue to exist, that is a continued battery. I don't think any attorney would ever make that argument, but that's an argument that I would make.
So once the patient says, I want to withdraw this medical care, and if the hospital insists on continuing it, that is a battery. So we think that Brophy falls perfectly in line with the rules that this court has applied. And in the VACO case, in the footnote there that we cite in our brief, the Supreme Court lists 31 different state court cases, state and federal cases, drawing that important distinction between the right to reject medical treatment and a asserted right to assisted suicide, including 2 cases from this court, the Brophy case, and I believe the guardianship of Doe case.
Counsel, I know you have your argument down pat and all of the support for it and all of that. That's great. I guess my question is just more fundamental. Do you not see the paternalistic part of this? That when you're talking about somebody like Dr. Kligler, who is a doctor who's treated patients his entire life, who's been able to define his own destiny, wake up every day and feel like he's actively living, to the point now of saying that because we're not going to read this and we're not going to say that our common law can evolve, we're not going to say that we can look to our Constitution and see whether or not there's something else that now is different than when we enacted it and when it's gone through history. That doesn't encompass the right of a human being to say, I don't want to be in a pain-induced, an opiate-induced stupor in my palliative care, that I'm just chock full of pain medication and I'm just laying there etherized on a couch somewhere. Do you not see that?
Your Honor, we certainly do sympathize with Dr. Kligler's
But
plight
forget
and
about
condition.
sympathize, because as he's dying in a way that he doesn't want to, the only thing that the interest that seems to be articulated here is because we feel better about the fact that you can't do that.
This is the problem with democracy. Again, democracy only benefits the majority. It's tyranny for minorities, and they have this coalition, and the bias. There's a strong bias against death. What I would like. Cause they always talk about how suicide is a a permanent solution to a temporary problem. But what is the solution to death? Because you're going to die anyway. So, what are you actually preventing? Right? All you're doing is prolonging their suffering. Um, I don't see the point. What are you actually trying to accomplish?
So, Your Honor, the state maintains an interest in Dr. Kleigler's human life, and the state more broadly retains an interest in human life of all Massachusetts citizens who would be impacted by a decision of this court creating a constitutional right to physician-assisted suicide. So if the legislature here in the Commonwealth decided tomorrow that that's a paternalistic approach as to a patient like Dr. Kleigler, the legislature tomorrow could pass a statute allowing a limited class of individuals in Dr. Kleigler's position to get access to a lethal medication in their life.
It is a paternalistic approach because, again, the state is the sovereign. The sovereign is the owner of all things and has the ultimate decision. The sovereign, and when I was reviewing Jean-Jacques Rousseau and the social contract, the sovereign owns all property. The subjects they actually belong to the sovereign. And the state is the sovereign. So the fact that, or the auspice is that you actually own your life, and that you own it's not true. The sovereign owns everything. They don't want to say that, but that's the paternalistic approach that they're taking, that the sovereign, and I don't know, I would refer you guys to go back to that live stream that I did, but basically it started with the king being put in in power because of God. So the king was basically the arm of God. And so by maintaining this sovereignty that the state is acting on behalf of its citizens, there is a religious connotation behind it. What they're essentially saying is that the state is God, or the state is acting on behalf of God. And it's the people that are doing it. That's what democracy is. The mob is infringing on the rights of the individual.
However,
They certainly could, if we were to say that there is a constitutional right here, they could certainly go and do their jobs to put the contours to that, like they do all the time.
unfortunately, Your Honor, I just don't think that's the case, because if this court were to constitutionalize a right to physician-assisted suicide, it would be very difficult, and I would suggest impossible, for this court to say, however, despite the fact that we're recognizing a fundamental constitutional right, we're going to narrowly define the class of individuals who have access to that constitutional
And you're
right.
saying the legislature can't do that? If we were to
That's not even the issue that is before the court. The issue is the right to physician or direct one's medical decisions. The right to, I just completely forgot what I was going to say. Anyway, it'll come back to me.
if we were as a first domino to say there's a right, don't they do that with access to abortion?
So if this
No,
court were to
don't they do that with access to abortion? Well, we said that there's a constitutional right, and the legislature goes off and puts the contours to it.
Sure, but they can't pass a statute that conflicts with the constitutional right that this court has recognized, even in the abortion.
Again, they're talking about judicial supremacy. So if the court recognizes the right to suicide, then it would basically curtail any measures implemented by the legislature.
Abortion context. So in this particular context, for example, if this court were to say there's a fundamental constitutional right.
Oh, I know what I was going to say. What I was going to say is that and I didn't look up Massachusetts, but I did look up Texas, and I believe Massachusetts has a similar provision that it's not just medical assistance, right? That you don't even have the right to terminate your own life. It's not under the criminal code, it's under the health and safety code, which they use the health and safety code as a backdoor to criminalize you terminating your own life. So they can apprehend you. That's what it is called in the health and safety code. It's an apprehension. But I mean, if y'all saw that video, they actually arrested that person, put him in a mental health facility in handcuffs, um, chained him to a bed, and forcefully injected him with all kinds of drugs. So it isn't. I mean, they're not going to call it a crime, but it's not just a crime for someone to assist you. It's a crime for you to do it yourself, also, or attempt to do it yourself. So they're trying to act as God. They want to be able to control your life and your death.
To physician-assisted suicide, and the legislature tomorrow says, well, we're going to narrowly cabin who has access to that right. They have to be competent adults, they have to be terminally ill, et cetera, et cetera. The lawsuit would be filed the next day saying you can't limit the class of people who have access to a fundamental right, and this court would be put in the position of having to do strict scrutiny and a complex balancing of the competing interests of the government and the people asserting that right in order to determine whether or not a new class of individuals should have access to it.
And don't we do that all the time?
Well, in this particular, of course, the court does do that, but what we're suggesting, and what I think the amicus briefs make very clear, is that it's near impossible, we would suggest impossible for this court to do that kind of balancing and to limit that access to the right in any way. I think it's important to recognize, so the other side bases its assertion of the right on the right to reject medical treatment. But then they say, but we think that this right to physician-assisted suicide should be narrowly limited to this class of people. And what this court has said as the right to reject medical treatment is that all persons have a general right to reject medical treatment, competent or incompetent. So that right has not been so limited to the extent that the appellants argue this right should be. The legislature can draw those lines, but this court is not in a position to draw those lines. And that's why we think it's important to leave that role to the legislature to make those social policy decisions and not to take that role on for this court. If I can make one more. Yes, Your Honor.
Has any state court found that there's a constitutional right to assisted suicide
The only
their
court,
state constitution?
the only court that tried to was the Ninth Circuit en banc Court of Appeals in the case that eventually became Glucksberg, where they were reversed. So other than that decision, no, Your Honor. Courts have routinely rejected the argument that there's a fundamental right to physician-assisted suicide. I think the importance, getting back to my initial point, the importance of the test, applying the deeply rooted in history and tradition test.
As I stated yesterday, I think the threshold issue is who actually owns your life, and that has never been articulated by any state court. Because without defining or without clarifying who actually owns one's life, because we keep assuming that we own our own lives, but no, we don't. And I would like to get that on a record. I would like for a court to actually say you don't actually own your life; the state owns your life.
It's important because, again, it cabins the role of this court and allows the legislature to play its separate role. And then I want to just make one point on some
I know
comments.
you're speaking fast because you're running out of time or have run out of time.
I welcome questions. Thank you.
But you keep going back to, fundamental rights being rooted in history, and I agree with you at least that is true. How do you take into account that now 10 jurisdictions have recognized that right, so that the history is changing, and so at least in 10 states, their citizens have this right to physician-assisted suicide? How do you account for that when we do our own historical analysis? Are we limited to the history of Massachusetts, or do we take into account the history of these other jurisdictions now that's evolving, given that common law, as Justice George has said, is an evolving thing?
Sure, thank you, Your Honor. That actually takes me to the exact point I was rushing to make, so I appreciate the question. And this is where we part ways a little bit with some of the arguments made by my friends, counsel for the Commonwealth, in that the test is and has always been, including last month in Roman, whether or not the asserted right is deeply rooted in history and tradition. Now, what my friends on this side and my friends on the other side have both argued is that, well, Goodrich changes that, Obergefell changes that, both those cases recognize you can look to more modern developments. However, if you read the opinions in both of those cases and the reasoning that this court, and the U.S. Supreme Court employ in both of those cases, what was at issue in those cases? Neither of those cases involved a question of, is there a fundamental right to marriage? It was conceded by all parties involved that there is a fundamental right to marriage. And so in determining whether or not there's a fundamental right in the first place, the test is still the same, whether or not it's deeply rooted in history and tradition. Now, what this court and the Supreme
I would push back on that. It's not. That's one component. Is it deeply rooted in American tradition? But it's also based on evolving standards of decency. Um, and then when it comes to the right to privacy, it's also whether you have a reasonable expectation of privacy. I think it's reasonable to, well, no, it's not, because we have put the government in that role, that the government is the third party between you and your doctor. So um, I think there used to be an expectation of privacy, but no, now everything is reported to the state health department. The government is involved in all that, but that's not the way that it should be. It should just be between you and your doctor. So that is, I mean, that's the same reason why abortion is being curtailed in many states because the government's role in it. The government is the one that issues the medical license. So because of that, it's putting. I mean, it's like, well, we gave the license, so now we don't want to be involved. But nobody forced you to give them a monopoly in the first place. It should be left to the free market. And just because you decided to limit who gets to provide medical service, that doesn't mean that it's on you, because even a private citizen can't do it, right? A private citizen, I mean, they talked about that yesterday, that you can't just give somebody a loaded weapon and assist them in terminating their life. So it's just, I mean, it's, I don't know. I mean, they created the problem where the government has so much power that it's too late to try to turn back the hands of time. Um, I'm an anarchist because I think the problem is too deeply rooted. The government has way too much power. I'm not saying there shouldn't be any government, but we should get rid of the system that we have and create something different.
Court and Obergefell both said is that when you're doing the next step of the analysis, when you're determining not whether a fundamental right exists, but whether a certain class of individuals has been denied access to that fundamental right, that's where you look to more modern developments. That's where you look to a more modern understanding of discrimination.
So is that why is that what you would say would be the reason that women have rights now? Because certainly under tradition and history, they weren't recognized. So are you saying things changed and that's why women have them? Or did women's rights get found somewhere in the Constitution?
No, so we think that the rights and the principles that were established at the very beginning continue to apply in full force here. That's more of an equal.
Apply to women. They didn't
What's that?
apply at all to women.
So
Right, women were not a part of the original Constitution. There was, I mean, I know this is before most people's time, but Gloria Steinem, and all those feminists during that time, they were trying to have a constitutional amendment to give women equal rights to men, and it passed in in Congress, but it wasn't ratified or something. And I think it's called the equal. Anyway, y'all can go look that up. Look up Gloria Steinem and the Equal Rights for Women amendment. But women are protected under substantive due process. It's intermediate scrutiny. Gender discrimination is intermediate, which is heightened. It has to be any type of discrimination against women or based on gender would have to be substantially related to a legitimate government interest. Um, yeah, but under common law, women did not have equal rights to men.
how did that happen then, if somebody didn't make a change?
Right, so that's more of an equal protection analysis, Your Honor, and that equal protection analysis, when you're looking at two different classes of people who've been treated differently, that's not limited to history and tradition, whereas a fundamental right question is a question of
It is related to history and tradition. There was a history and tradition of discriminating against women.
history and tradition, and so that's why we think the analysis is different here and can be and ought to be cabined to history and tradition. And so in this case, and applying the history and tradition test in light of Obergefell, in light of Goodridge, if this were a case where, most individuals had access to a right to physician-assisted suicide, but there was a narrow class of people who did not have that access, then you would have an argument that, well, you can look at more modern developments as to discrimination against that class and give that class of folks a right to physician-assisted suicide. Here the question is the threshold question of whether such a right even exists in the first place. And in fact, that brings me back to the point.
No, the threshold question is who owns your life?
Point that I was making earlier about the inability of this court to cabin a right to physician-assisted suicide to a narrow class of people. So if the court were to say in this case, well, we're going to find a fundamental right to physician-assisted suicide, but limit it to this narrow class of people, then 10, 15 years down the road, parties come in, or maybe 2 or 3 years down the road, parties come in and say, well, that was the understanding of physician-assisted suicide at the time, but we're in this different class of people. We should have access to that right too. Look at Obergefell. Look at modern developments. We've been discriminated against. And then what does this court say in response to this argument? How does this court cabin the fundamental right to physician-assisted suicide to the narrow?
Why does he care? I don't understand. Why does he care? He doesn't work for the Attorney General's office. This is a private attorney who decided to form this coalition to prevent people from having a right to die. I don't understand.
Class of people who are asking for it here. The legislature can draw lines like that, but this court cannot draw lines like that when it comes to...
You of course recognize they have an equal protection argument too.
So there's, of course, an equal protection argument. So if they were able to say, we are an narrow class of people who are being treated differently in terms of accessing a right available to others, but that's not the case. So Mr. Kleigler, if he ends up in a position where he's on life support or receiving some other sort of medical treatment, and he asserts, I want to reject that treatment or withdraw that treatment, he's in the same position as every other Massachusetts citizen right now.
He's not in the same position as a dog because the dog actually has a right to die.
Has equal access to that right. So there is no equal protection violation in terms of the rights that are afforded to all Massachusetts citizens. So there is no equal protection violation. There is no substantive due process violation. For that reason, rational basis review applies. And for all the reasons laid out in my friend's brief for the Commonwealth and the record below, the common law prohibition easily satisfies rational basis review. We'd ask the court to affirm the decision below. Happy to answer any other questions from the court. Otherwise, I'll rest on my brief and ask the court to affirm.
Yes, Jason.
Okay, so that's why it's so important in how you frame the issue when you're writing your amicus brief, because the way that the attorney for the appellant framed it is based on the right to direct one's medical decisions, which is subject to rational basis, which is the lowest tier of scrutiny. Most state action is going to pass under rational basis. The goal is to get it to strict scrutiny by articulating a fundamental right, which is the right to life. So I think the attorney dropped the ball. We can say that this should come from the legislature, right? But the legislature is never going to support this because the majority doesn't care. This doesn't impact the majority. This is going to impact the minority. Even when people are put in a situation, the family does not want that person to have the right to die. I don't trust the only person I would trust with that decision would be my brother, because my brother is more dispassionate. I think that my brother would respect my rights. I damn sure would not trust my parents. I think, especially my ex-mom, she would probably want me to just, die a slow, agonizing death. As long as I was here to provide her with narcissistic supplies, she wouldn't give a shit. So, Yeah, democracy is so dangerous. And again, we don't really actually have democracy. It's a Republican form of government, but it's being run as a democracy. So I'm going to go ahead and end this live stream. Thank you. Oh, we have some comments. I haven't watched that. I'm going to check that out. Thank you for I'll actually see if I can watch that tonight. Um, thank you for that. Yeah, I'm definitely going to check that out. So thank y'all. Y'all have a good day.